The only two provisions which point to them, and include them, treat them as property, and make it the duty of the government to protect it. No other power, in relation to this race, is to be found in the Constitution, and, as it is a government of special, delegated powers, no authority beyond these two provisions can be constitutionally exercised. The government of the United States had no right to interfere for any other purpose but that of protecting the rights of the owner, leaving it altogether with the several states to deal with this race, whether emancipated or not, as each state may think justice, humanity, and the interests and safety of society require. The states evidently intended to reserve this power exclusively to themselves. No one, we presume, supposes that any change in public opinion or feeling in relation to this unfortunate race in the civilized nations of Europe or in this country should induce the court to give to the words of the Constitution a more liberal construction in their favor than they were intended to bear when the instrument was framed and adopted. Such an argument would be altogether inadmissible in any tribunal called on to interpret it. If any of its provisions are deemed unjust, there is a mode prescribed in the instrument itself, by which it may be amended, but while it remains unaltered, it must be construed now, as it was understood at the time of its adoption. It is not only the same in words, but the same in meaning, and delegates the same powers to the government, and reserves and secures the same rights and privileges to the citizen. And as long as it continues to exist in its present form, it speaks not only in the same words, but with the same meaning and intent with which it spoke when it came from the hands of its framers, and was voted on and adopted by the people of the United States. Any other rule of construction would abrogate the judicial character of this court, and make it the mere reflex of the popular opinion or passion of the day. This court was not created by the Constitution for such purposes. Higher and graver trusts have been confided to it, and it must not falter in the path of duty. What the construction was at that time, we think can hardly admit of doubt. We have the language of the Declaration of Independence and of the Articles of Confederation. In addition to the plain words of the Constitution itself, we have the legislation of the different states before, about the time, and since the Constitution was adopted. We have the legislation of Congress from the time of its adoption to a recent period, and we have the constant and uniform action of the executive department, all concurring together and leading to the same result. And if anything in relation to the construction of the Constitution can be regarded as settled, it is that which we now give to the word citizen and the word people. And upon a full and careful consideration of the subject, the court is of opinion that, upon the fact stated in the plea in abatement, Dred Scott was not a citizen of Missouri within the meaning of the Constitution of the United States, and not entitled as such to sue in its courts, and, consequently, that the circuit court had no jurisdiction of the case, and that the judgment on the plea in abatement is erroneous. We are aware that doubts are entertained by some of the members of the court whether the plea in abatement is legally before the court upon this writ of error, but if that plea is regarded as waived or out of the case upon any other ground, yet the question as to the jurisdiction of the circuit court is presented on the face of the bill of exception itself, taken by the plaintiff at the trial, for he admits that he and his wife were born slaves, but endeavors to make out his title to freedom and citizenship by showing that they were taken by their owner to certain places, hereinafter mentioned, where slavery could not by law exist, and that they thereby became free, and upon their return to Missouri became citizens of that state. Now, if the removal of which he speaks did not give them their freedom, then by his own admission he is still a slave, and whatever opinions may be entertained in favor of the citizenship of a free person of the African race, no one supposes that a slave is a citizen of the state or of the United States. If, therefore, the acts done by his owner did not make them free persons, he is still a slave, and certainly incapable of suing in the character of a citizen. The principle of law is too well carried to be disputed, that a court can give no judgment for either party, where it has no jurisdiction, and if, upon the showing of Scott himself, it appeared that he was still a slave, the case ought to have been dismissed, and the judgment against him, and in favor of the defendant for costs, is, like that on the plea in abatement, erroneous, and the suit ought to have been dismissed by the circuit court for want of jurisdiction in that court. But, before we proceed to examine this part of the case, it may be proper to notice an objection taken to the judicial authority of this court to decide it, and it has been said that as this court has decided against the jurisdiction of the circuit court on the plea in abatement, it has no right to examine any question presented by the exception, and that anything it may say upon that part of the case will be extrajudicial and mere obiter dicta. This is a manifest mistake. There can be no doubt as to the jurisdiction of this court to revise the judgment of a circuit court and to reverse it for any error apparent on the record, whether it be the error of giving judgment in a case over which it had no jurisdiction, or any other material error, and this, too, whether there is a plea in abatement or not. The objection appears to have arisen from confounding writs of error to a state court with writs of error to a circuit court of the United States. Undoubtedly, upon a writ of error to a state court, unless the record shows a case that gives jurisdiction, the case must be dismissed for want of jurisdiction in this court. And if it is dismissed on that ground, we have no right to examine and decide upon any question presented by the bill of exception or any other part of the record. But writs of error to a state court and to a circuit court of the United States are regulated by different laws and stand upon entirely different principles. And in a writ of error to a circuit court of the United States, the whole record is before this court for examination and decision, and if the sum in controversy is large enough to give jurisdiction, it is not only the right, but it is the judicial duty of the court to examine the whole case as presented by the record, and if it appears upon its face that any material error or errors have been committed by the court below, it is the duty of this court to reverse the judgment and remand the case. And certainly an error in passing a judgment upon the merits in favor of either party, in a case which it was not authorized to try, and over which it had no jurisdiction, is as grave an error as a court can commit. The plea in abatement is not a plea to the jurisdiction of this court, but to the jurisdiction of the circuit court. And it appears by the record before us that the circuit court committed an error in deciding that it had jurisdiction upon the facts in the case admitted by the pleadings. It is the duty of the appellate tribunal to correct this error, but that could not be done by dismissing the case for want of jurisdiction here, for that would leave the erroneous judgment in full force and the injured party without remedy. And the appellate court therefore exercises the power for which alone appellate courts are constituted, by reversing the judgment of the court below for this error. It exercises its proper and appropriate jurisdiction over the judgment and proceedings of the circuit court as they appear upon the record brought up by the writ of error. The correction of one error in the court below does not deprive the appellate court of the power of examining further into the record and correcting any other material errors which may have been committed by the inferior court. There is certainly no rule of law, nor any practice, nor any decision of a court which even questions this power in the appellate tribunal. On the contrary, it is the daily practice of this court, and of all appellate courts, where they reverse the judgment of an inferior court for error, to correct by its opinions whatever errors may appear on the record material to the case, and they have always held it to be their duty to do so where the silence of the court might lead to misconstruction or future controversy, and the point has been relied on by either side, and argued before the court. In the case before us, we have already decided that the circuit court, in deciding that it had jurisdiction upon the facts admitted by the pleadings, and it appears that, in the further progress of the case, it acted upon the erroneous principle it had decided on the pleadings, and gave judgment for the defendant, where, upon the facts admitted in the exception, it had no jurisdiction. We are at a loss to understand upon what principle of law applicable to appellate jurisdiction it can be supposed that this court has not judicial authority to correct the last mentioned error because they had before corrected the former, or by what process of reasoning it can be made out that the error of an inferior court in actually pronouncing judgment for one of the parties in a case in which it had no jurisdiction cannot be looked into or corrected by this court. Because we have decided a similar question presented in the pleadings, the last point is distinctly presented by the facts contained in the plaintiff's own bill of exceptions, which he himself brings here by this writ of error. It was the point which chiefly occupied the attention of the counsel on both sides in the argument, and the judgment which this court must render upon both errors is precisely the same. It must, in each of them, exercise jurisdiction over the judgment and reverse it for the errors committed by the court below, and issue a mandate to the circuit court to conform its judgment to the opinion pronounced by this court by dismissing the case for want of jurisdiction in the circuit court. This is the constant and invariable practice of this court, where it reverses a judgment for want of jurisdiction in the circuit court